the time of the commencement of that suit, actually voluntarily resides and carry on the business or personally works for it. Your Honor, hence this court has full jurisdiction to adjudicate this matter. Counsel seeks permission to start with the state tax at page 7, Your Honor. ABC tax is a major manufacturer of bedsheets and towels, bath towels, and having registered office in Mumbai. It hosts some of the India's top hotels, resorts, and clients that purchase the same yearly bulk order. In January 2020, DL Hospitality, one of the largest chains of hotels and resorts, placed a yearly bulk order of bedsheets and towels, bath towels, totaling 1 crore rupees. The contract do not have aggregate liability gap and also do not have disclaiming liability gap, which says either of the party for indirect consequential losses or damage, loss of profits, loss of reputation. Your Honor, delivery of lots. First lot comprising 80% was to of order value was to be delivered in February 21. And second lot, 20% of the consignment value was to be delivered in June 21. Your Honor, penalty clause, which states the contract had penalty of 20% of the relevant lot value if the quality was substandard. And also, the contract had a penalty of 10,000 per week delay in the delivery. And also, the force majeure clause was included in the contract, which expressly provides pandemic will not be included in the contract. Also, Your Honor, the contract had termination clause, which says termination clause if other party commits the material. The time was the essence of the contract. Your Honor. First lot of delivery. ABC successfully delivered its first lot. Payment was done within 15 days. Reported guest at the flagship hotel complained about the poor quality of social media as an inquiry. In June 2020, DEF sent a letter highlights the non-delivery of the second lot and alleged poor quality of the first lot. However, the contract Counsel seeks permission to bench is satisfied with the facts of this case to move to ask the first question.
Yes, please continue.
And this whether DEF is in fact to take 20% penalty, with the most respect, it is submitted to court and legal court. Yes, DEF is entitled to take 20% penalty on the following. Your Honor, under section 16, subsection 1 of Sale of Goods Act, implied relation to makes known to the for that purpose. In our case, Your Honor, DEF expressly notes to ABC that for which purpose we are buying for resorts orders to be used by the guest. In our case, there is an implied relation that goods ABC was not ABC. About that poor quality for this purpose, and ABC was not applicable. As per section 16 subsection 2, which says where goods are bought by condition that goods shall be merchant. Here goods were bought by the description, but the towels were used but not of merchantable quality. They were criticized by the guests. Posts. Therefore, it harms the daily reputations. In concerned case of Your Honor, Valdius Master, which says breach of implied condition of fitness and enters the buyer to claim remedies, even if the buyer had an opportunity. Your Honor, we have inspected the goods, but those defects were latent as the fabrics were worn so many washes and acceptance has been confirmed. But if you look upon the section 59 of sale of goods, which says if goods breach a warranty, a buyer cannot reject the goods, but can claim damages. As a breach of warranty. Your Honor. And also in similar case, Union of India which says acceptance of goods does not 1.3 argument. The contractual penalty enforceable under section 74. Your Honor, section 74 clearly says when a contract specifies sum to be paid in case of a breach, the party complaining about the breach the reasonable compensation not exceeding the stipulated amount. Your Honor, condition was very much clear. 20% of the quality of the goods. In February 20, the goods which was delivered was not up to the mark and was of poor quality. Same was criticized. As per section 74, we are entitled to claim that 20% penalty. In concerned case, Your Honor, 216 is so far. Supreme Court held that where a contract provides for liquidated damages and breach is established, the stipulated amount can be awarded if it is a genuine estimate of losses.
Counsel, kindly come to section 40. You have a where this is also there. Kindly come to section 40. So once the initial lot was exceeded by 80%, you had an opportunity to examine the goods. And was there any email on your part to the defendant company that there was a defect in the goods? Because the defect came to knowledge in March 2020. Was it not deemed acceptance on your part as covered in section 42? You have section 42 in front of you.
Yes, Your Honor. The beneficiary said that buyer need to accept the goods. When he had paid the good for a reasonable period of time. And here we paid the good for 3 months and above. But Your Honor, if we look upon section 59, which says that in case of breach of precondition, we can claim damages. As explained earlier.
My query is in case under section 42, as you are admitting that there was acceptance of goods on your part.
Yes, Your Honor.
Then where is the question of your claiming damages towards poor quality of the first consignment? Because admittedly, as per your proposition, you not send them any email objecting to the quality of the goods.
Your Honor, they were social.
That's perfectly fine. But what was done at your part? You had received the goods, you had accepted the goods. So what was done at your part to intimate that the goods have been rejected?
Your Honor, we have to clearly verify that it will be 20% penalty to the effective.
You could come to that. Please read the penalty on account of poor quality of the first consignment.
Yes.
In case you already accepted the goods as per section 42, then where does that question come? You have opportunity to inspect. You had opportunity to inspect it. We can certainly understand they were dated or dated. But you did not raise an issue in spite of the fact that there were emails or there was social media news in March 2020 that there is a quality defect. Actually, to claim damages on account of poor quality of goods.
You is correct, Your Honor, the right has was given. But the facts are latent, and on our aspect we try best. But if you put it in this way,
Let's come to section 15 and what you because the regular out of section. Let's read 59.
remedy for breach of warranty. When there is a breach of warranty, as compared to any breach of condition on part of the seller, and a breach of warranty, the buyer is not by the reason only such breach of warranty entitled to reject the goods, but he may settle against the seller breach of warranty in diminution or extinction of the right. But we are sue the seller for damages for a breach of warranty. The fact that buyer has set up a breach of warranty in diminution or extinction of the right does not prevent from suing for the
Your claim of damages is covered under which section and which clause of section 15A?
1B.
One. Let's proceed further. Let's go. If you have any law Have you cited any law? That's the case. Judgment, have you supported? Have you cited some judgment in some?
Union of India versus Laila, which says acceptance of good does not prevent the bias.
This one. Please
Acceptance of goods does not prevent the buyer from claiming the compensation for defects or discovered subsequently.
Which portion are you referring from? Union of India versus
Around 1.2.
Kindly read from the judgment. Are you reading from the judgment? You are citing the law and reading from the judgment.
Page 14 of that relevant part. The respondent was therefore entitled to claim the compensation on the ground that the government of India had committed a breach of warranty.
This is not the finding. You are referring what was argued. Kindly come to the reference. We are at the section 59(1)(b) is referred. Is that referred in this document?
No, that was
Anything else you want to support your case with?
yes, Your Honor. As per section 2(1)(d) of BSA, definition of evidence includes all statements made before the court and all documents including electronic. Counsel 6 wish to start with the second issue if the bench is satisfied. At whether the COVID-19 pandemic and resultant lockdown imposed was qualified as force majeure event. With the most respect, it is submitted that no, the COVID-19 pandemic and lockdown does not qualify as a force majeure event on the following grounds. First, force majeure events mean extraordinary events or circumstances beyond human control. Such an event is described as an act of God. And also, FM clause frees both the parties from contractual liability. The exact events considered as a force majeure event depends on contract wording. So it's important for a contract to be specific about which events are to be covered. You know, there is a clause that is a disclaiming liability, which means that disclaiming liability is a liability that excludes or restricts the party responsibility for certain losses that arise in the future due to breach. Inclusion of this clause makes party free from those losses, but absent not including this clause makes on account of interest losses, loss of profits and
Is force majeure defined in any of these statutes?
as per section 32 of contingent contract.
What does it say?
That's to do or
I'm asking for the definition of force majeure. Is it defined in any force majeure? Is it defined in any statute?
no, in any kind of clause it is not defined, it is a clause in a contract.
Where would force majeure come into operation? This is what a force majeure clause come into operation.
Act of war, strike,
Will it be any act which is beyond human control? Force majeure any act which is beyond human control? So will COVID-19 not fall in that category?
as per the review is done, Your Honor, as per section 9 and section 13, section 9 words promises can be expressed or implied. Section 13 words defines consent, where two or more parties agree. In our case, ABC here both agree to the pandemic will be not counted.
How could they agree whether COVID-19 would apply or not? Because COVID-19 was not in picture in February. The only question is that whether COVID-19 would be covered under force majeure generally or not.
No, Your Honor.
So any law to support this contention?
Yes, Your Honor.
Right? Be quick and kindly refer the law.
In the citation MS references is ready on citation. It is in issue 2.3.2.
Okay.
And post more 2.3.2 states that force mere immersion hardship does not amount to impossibility to obligation. Termination of leave and license agreement citing COVID-19 pandemic as force majeure invalid when force majeure was not properly invoked. Reduction in license fee already addressed the hardship caused by pandemic.
So there is not been. Thank you, Council.
Council seeks permission to go my co-counsel for the further issue.
Please.
Council seeks the permission to close the lines. Is it on? So, Council seeks the permission. But it does not prevent the buyer from regulating the contract where the contract itself provides for the termination clause and where the breach affects the substance of the entire agreement. Your Honor, the contract complicated supply in the installments and the breach went to the root of the future performance. DES was legally entitled to reject subsequent consignment and terminate the contract. Your Honor, in the concerned case law, Union of India versus Children Quarter Mills, where Supreme Court held that the breach of the implied conditions as to quality and fitness entitled the buyer to reject the goods and repudiate the contract, particularly where such breach is fundamental in the nature. So, Your Honor, moving to the next argument. Council is seeking your attention to this point where ABC conducted trades the maxim Dulus Commodium Fact represents the insurance proprietary which means that no person can take
to you requesting for an extension of time,
Yes.
to which no reply has been sent by you.
Yes.
And
So it-
emails have been sent, again no reply from your side. And then what is being argued is that no person should be allowed to take advantage of the going on. Does that silence does not amount to acquiescence on your part that you agreed to an implied extension of time during the lockdown period?
Questions. Mere silence does not amount to waiver of the contractual rights. Defects were taken and seriousness of the quality defects became evident only after the gradual use as guests of plane accumulated. And moreover,
The acquiescence is not for the defects. The acquiescence is you are not giving a reply to their letter seeking extension of time. What do we say about that? On account of COVID-19 pandemic. My question is that.
Your Honor, my client has no contractual duty to reply to the letters as well as discretionary or fit to reply on that very point of the time.
Are you aware of some Supreme Court orders during the COVID-19 period?
Sorry, can you repeat your question?
Aware of some judgment or some order by the Honorable which prevented liquidation from running during the COVID-19 period?
Yes.
Was liquidation suspended during the COVID-19 period? That is my question.
You are basically asking which companies were
Achha, let's come to this.
It's not running.
Let's come to your cause. Achha, but you are basically seeking now the relief of termination of the contract for non-compliance with the particular period. Is that so?
Yes, for the quality breach and for the non-delivery of
The
the
quality breach was brought to the notice of the defendants.
yes, after our customers have reported the videos and then the same was also communicated to the ABC company. So that was
Did you
communicated.
serve any notice or was the filing of dispute itself a notice to them? Did you serve any prior notice to them before filing this regarding the quality?
No, we have not served any personal notices to them.
Whether you should have got any expert opinion regarding the effect of this which we have selected.
He has opportunity to examine latest dependent not as for the bulk textile supplies made for the hotel use. Quality issues emerge only after actual use and the laundry, and it is a fabric durability which can only be discovered after the use. And hence, after this, our experts have also examined the same, and the defects were found.
Have you enclosed a copy of the expert's opinion on the with your claim? And how do you prove your stand?
By customers videos and their feedback.
News published in the newspaper is admissible in the court or not?
Your Honor, according to the section 2 of the BA definition of the evidence include all the statements made before the court and all the documents including electronic records. So hence we have customers feedback.
But this news was published in the newspaper. Whether any other evidence you have produced to prove your stand, have you enclosed this document with your suit?
We have made to them notice that
Notice.
what are you asking?
My query, simple query. Have you produced any cogent evidence to prove their stand? This material is totally defective.
regarding defective supply. What would be the evidence you could produce in support of your claim? आपके केस के सपोर्ट में आप क्या एविडेंस लगाओगे? What will you bring before the judge so as to substantiate your claim? He's asking you this.
Customers' feedback and the reports for the non-suitability, and also after the forensic experts' reports that will be the support to our argument.
Thank you. Okay.
The council seeks permission to close the dials. Much obliged, Your Honor. May it please this honorable court. The council and the co-council are appearing on the behalf of Justice ABC Textiles. The council shall address jurisdiction of this honorable court, brief facts and issues framed and argument on issues 1 and 2. Whereas the co-council shall address the main issue and conclude it with the prayer. The council seeks permission to state the jurisdiction of this honorable court. Much obliged, Your Honor. Your Honor, the jurisdiction of this honorable court arises on 4 clear grounds: civil jurisdiction, commercial jurisdiction, pecuniary jurisdiction, and territorial jurisdiction. First, under Section 9 of Code of Civil Procedure 1908, civil courts have jurisdiction to try all suits of a civil nature unless expressly barred. Second, the present dispute arises out of a contractual rights and obligations, and there is no express or implied statutory bar. Second, the dispute arises out of a commercial contract for supply of goods entered in the ordinary course of business. It squarely falls within the honorable court has subject matter jurisdiction under of the Commercial Code Act. Your Honor, the honorable court has registered office in Mumbai. The contract was executed and partly performed in Mumbai, and the course of action arose of this honorable court. Therefore, Your Honor, in the absence of any statutory bar, this honorable commercial court is fully empowered to adjudicate the present dispute and grant the relief sought by the defendant. The council seeks permission to state the facts of this case.
Second.
Much obliged, Your Honor. The defendant ABC Textiles Private Limited is a reputed manufacturer and supplier of bedsheets, hand towels and bath towels with its registered office in Mumbai. In January 2020, DEF Hospitality placed a yearly bulk order worth Indian rupees 1 crore with the defendant for supply of textile goods under a duly executed procurement contract. The contract did not contain any great liability cap and any clause excluding liability for indirect or consequential losses, including loss of reputation, loss of business, or loss of goodwill. The contract required delivery in 2 consignments, 80% in February, while the remaining 20% in June 2020, and the contained clauses relating to penalty, force majeure, and timely delivery being the essence of the contract. The defendant successfully delivered the first consignment within the time in February 2020. The goods were accepted without objection and payment was made in full, confirming satisfaction. No immediate rejection was seen. The alleged defects, if any, were never proved through inspection reports, expert evidence, or laboratory analysis. In late March 2020, the Government of India imposed a nationwide COVID-19 lockdown, which severely disrupted supply chains, raw material imports, and labor availability. These circumstances were beyond the control of the defendant and directly affected its ability to deliver the second consignment within the stipulated time. The defendant promptly informed DEF Hospitality of these difficulties and sought a reasonable extension good faith. Despite being informed, DEF Hospitality unilaterally terminated the contract in June 2020 without granting the defendant any opportunity to cure the delay or resume performance after lockdown restrictions eased. As a result, the termination was arbitrary, premature, and contrary to settled principles of contract law. The Council seeks permission to state the issues of this case. Much obliged, Your Honor. The first issue before this Honorable Court is whether the DEF is entitled to claim a 20% penalty for poor quality. So my answer to this issue is no, the plaintiff is not entitled to impose the penalty. Your Honor, the Council made 3 brief submissions. It is respectfully submitted that the plaintiff has failed to discharge the as no inspection reports, no laboratory tests, no expert evidence, no contemporaneous rejection notice have been produced before this Honorable Court. Mere allegations of guest complaints, unsupported by evidence, do not establish breach of law. Under Section 42 of the Sales of Goods Act 1930, acceptance of goods accepts delivery. In the present case, the plaintiff accepted the delivery, used the goods, raised objections only after use. Thus, the plaintiff is deemed to have accepted the goods and cannot impose penalty for alleged defects. As per Section 59 of Sales of Goods Act, after acceptance, remedy lies only in damages, not penalty. Third, even where a contract provides for penalty, Section 74 of the Indian Contract Act 1872 mandates that only reasonable compensation may be awarded and penalty clauses are subject to judicial scrutiny. The plaintiff has neither proved actual loss nor shown how 20% penalty is reasonable. In Kailash Associates vs. DDA, the Supreme Court held that in absence of loss or breach, penalty cannot be imposed. Therefore, the plaintiff is not entitled to impose a 20% penalty and claim deserves to be rejected. The second issue before this Honorable Court is whether the COVID-19 pandemic and the resultant government-imposed lockdown qualify as a force majeure event. Yes, COVID-19 lockdown constitutes a force majeure event. Your Honor, the Council makes 3 brief submissions. First, force majeure refers to the events that are unforeseeable, beyond the control of parties, and prevent performance despite best efforts. The nationwide availability supply chains. This clearly falls within the doctrine of force majeure. Second, where a contract contains a force majeure clause, it is governed by Section 32 of Indian Contract Act 1872. Pandemic is not mentioned. Courts have held that force majeure clauses must be interpreted commercially and purposely. In Energy Watchdog vs. CERC, the Supreme Court held that force majeure applies when performance becomes impossible due to external events. Third, even otherwise, under Section 56, temporary impossibility suspends obligation. The defendant did not refuse performance. Instead, it promptly informed the plaintiff, requested reasonable extension, and acted in good faith. In Satya Bhatta Bose vs. Mugniram Bengal, the Supreme Court held that temporary impossibility does not terminate the contract but suspends performance. Therefore, the defendant is entitled to be protected under force majeure, and delay caused by lockdown cannot attract liability.
Counsel, as you pointed out at the start of your arguments, that it's a commercial dispute.
Yes.
And which provision deals with commercial disputes?
Under Section 2, Subsection 1 clause, Commercial Court Act.
Have you read Section 12 of Commercial Court Act? Was there any pre-litigation mediation before started and you refer to that provision, it will tell your case only whether that compliance was made or not. Are you aware of the provision section 12A?
No, sir.
So then we come to issue number 1, that whether DPF is entitled to claim a 20% penalty for poor quality.
Yes, sir.
So as you can understand, it's a hospitality industry.
Yes, sir.
So you had supplied towels and bedsheets, and the guests who have used it, they have posted videos and pictures on social media complaining about the quality. So what more evidence was required to show that the quality was good?
So social media reports are not the legal evidences.
Can you cite some judgment on this? That the social media reports are not admissible in evidence reports.
From this case is that internet report damages are not recoverable. Social media bad lack of goodwill was not within contemplation.
And then force majeure clause. Once there is a specific clause in the Contract Act which specifies force majeure, because the contract is same. Any act beyond the control of the parties will not expand the scope of the contract. So how do you explain that force majeure would cover a pandemic of COVID-19 also? Do you have any Supreme Court judgment to support this? That
Yes, sir.
COVID-19
Energy watchdog versus the ERC.
and does that cover COVID-19 specifically? Can you read out the relevant paragraph which you want to refer?
Yes, sir. The key principle lies in this is that force majeure applies when performance becoming possible due to uncontrollable events. Government lockdown halted imports.
And all the change.
The co-counsel the third issue before plaintiff was unlawful and unjustified. Your Honor, the co-counsel made three brief submissions. First, there was no refusal or appointment made by the defendant. Your Honor, termination under contract law presupposes a clear refusal or unwillingness to perform. In the present case, the defendant never refused performance. The defendant never abandoned the contract. At best, there was a temporary delay caused by force majeure circumstances. Therefore, this does not attract Section 39, i.e. repudiation of contract. Repudiation basically means when party clearly refuses to perform. ABC never repudiated, it requested time for extension. In Hind Construction Contractors versus State of Maharashtra, the Supreme Court held that mere delay without refusal to perform does not justify termination. Second, delay caused by force majeure cannot amount to material breach. Your Honor, termination for cause requires a material breach that goes to the root of the contract. A delay occasioned by an extraordinary external event coupled with a request for extension cannot be treated as a material breach. In Satyabrata Bose versus Mugni Ram Bangalore, the Supreme Court held that temporary impossibility suspends performance. It does not destroy the contract. The defendant acted in good faith. In Erosion Enterprises versus Union of India, the Supreme Court held that termination must be reasonable, proportionate, and exercised in good faith. Therefore, Your Honor, the plaintiff's termination was premature, was arbitrary, was contrary to settled principles of contract law,
and is liable to be set aside. Much obliged, Your Honor. Your Honor, a combined reading of sections included are Section 32, which defines the force majeure or contingent contracts. That's why COVID-19 lockdown suspended the performance. Section 39, that shows the termination requires refusal to perform. Mere delay is not the refusal. Section 56, that defines that temporary impossibility due to lockdown does not terminate the contract. Section 73, that defines that compensation requires the proof of actual loss. Section 74, which defines that penalty not automatic, only reasonable compensation is allowed. These are the sections of the Indian Contract Act, along with the sections 42 that defines acceptance of goods, bars, rejection and penalty for quality. Section 50 defines after acceptance, remedy lies in damages, not termination or penalty. These are the sections of the Sale of Goods Act, clearly shows that the penalty is unforeseeable, delay was excusable, and arguments advanced and authorities cited. It is humbly requested that the Honorable Commercial Court of Mumbai may be pleased to adjudge and declare that dismiss the suit filed by the plaintiff as being devoid of merit, declare that the defendant is not liable to pay any penalty for alleged substandard quality of the first consignment, the same having been duly accepted by the plaintiff without objection, holds that the delay in delivery of the second consignment was caused due to the COVID-19 pandemic and government-imposed lockdown, constituting a force majeure event under the contract. Declare that the termination of the contract by the plaintiff was arbitrary, unlawful and unjustified.
Kindly refer section 59 of the Sale of Goods Act. You have to be there. You have referred this provision. Kindly section 59.
Section 59 of Sale of Goods Act.
Yes. Let me ask a question. Do you believe that there was a breach of warranty on your part in not supplying the right quality of towels and bed sheets? Do you agree to this part?
No, sir.
Since there were complaints, and obviously the customers who were staying in the hotels, they had no enmity towards you. So why would they be making false complaints against you that the quality was not proper, and obviously people had posted this news on the social media as well. So will you agree that there was a breach of warranty on your part of not supplying the appropriate quality of goods? Will you agree to this?
No, sir.
So that is perfectly well. Then how do you regulate for 59(1)(b)? Is the plaintiff not entitled for damages for breach of warranty on your part? How do you regulate for 59(1)(b)? Because you have referred to section 42. We admit that obviously there is due acceptance on your part. But what about the breach of warranty on your part? How do you regulate for 59(1)(b)? In case there is a conflict between section 42 and 59(1)(b), how do you regulate of this? Again, kindly refer the provision. What would be the appropriate remedy against you yourself point out? If they can't sue you for penalty, what can they sue you for?
Damages.
You can refer me the provision. You have the section. Tell me what can they sue you for?
Damages.
To what extent? What should be the extent of their damages?
This is not mentioned basically in the contract.
In the contract, it is not mentioned that what can they sue you. So it has to be mentioned that what should be the quantum of the damages in the contract. Is it necessary to be mentioned?
No.
Then, so what should they sue you for? You supplied them 80% of the goods. They have paid you the entire price within 15 days. So in case the quality is not proper, how can you compensate them? We have to balance the fees. So how can you compensate them? By refunding that 80% of the price, are you ready to do that? You are not willing to do that. So how are you ready to compensate them? Will you receive back the defective goods?
But why compensation?
Are you ready to receive back the defective goods then? The goods are not actually, obviously they have set your standard. Because since the goods have not been accepted, are you ready to receive back those goods?
But that evidence is not correct.
We are not talking about evidence. We you don't want to give them any damages. You say it is not mentioned in the contract. So are you ready to take back the goods as a goodwill gesture?
No.
See, they are suppliers who obviously are supplying the goods. So you are not suggesting anything. That absolutely the claim should be dismissed. With no
Full
need
information
to.
should be given.
So irrespective of the fact that whether you have supplied them defective goods, so the entire claim should be dismissed. That is what we are pointing out. Achha, kindly come to another section you had read for, was section 32, contingent contract. We come to that. Kindly read that section. Section 32.
Section 32 or 31?
32.
Enforcement of contracts contingent on an event happening. Contingent contracts to do or not to do anything if an uncertain future event happens cannot be enforced by law unless and until that event has happened. If the event becomes impossible, such contracts become void.
So is the contractual liability is void or voidable?
Void.
How?
Because
Have you repudiated the contract or have you sought time to perform the part of the contract?
both.
You have not repudiated the contract. You have only sought time
Sought time.
because of COVID. So what does it then? Void or voidable? It is not impossible the performance of the contract. You are ready to do it. You are ready to supply the 20% balance goods. So is it void or voidable then?
Voided.
Voidable at instance of whom?
And
You are the supplier or you are the purchaser.
supplier.
How can it be voidable? Seeking extension. Who can avoid the contract? Or is it for the plaintiff not to avoid the contract? In case he's seeking time and they're not ready to give you the time, so who can avoid the contract then? So does section 22 come into operation in this case? Will it be applicable? No? Okay. Then how are you justifying the force majeure clause under this section? Since you're not covered under section 32 as per your own case, then which statute are you bringing your case
Like
under?
COVID-19 lockdown suspended the performance.
Which statute? Because obviously you've given up a claim under section 32 and then 59 months you are not able to let it out. Then which particular part of this, which part of law are you bringing our claim under?
56, section 56.
Can I read the section 26 also?
Agreement to do impossible act. An agreement to do an impossible act is void. Contract to do act afterwards becoming impossible or unlawful. A contract to do an act which, after the contract is made, becomes impossible or by any reason of some event which the promiser could not prevent, unlawful becomes void when the act becomes impossible or unlawful.
So which part of the section are you bringing your matter? Because this again says it is impossible and in your case you are not saying it is impossible. And this again talks of a void contract and you are not talking about a void contract. Though council can certainly assist you. Please,
Section 32.
that you told me that you are not going to be very center. So then, do we have any other section which we can bring our case under? Do you know law declared by the Honorable Supreme Court is so you cited a Supreme Court judgment which says COVID-19 is force majeure. So bring our case under that. It is also not what the Honorable Supreme Court declares. That is also kindly refer the judgment on.
Energy watchdog versus CERs. Force majeure applies when performance becomes impossible due to uncontrollable events.
Kindly read out that particular part which uses COVID-19 is covered under force majeure.
Government in lockdown halted imports and labor. COVID-19 restrictions qualify as force majeure even if not expressly named.
This is your answer.
Thank you. Much obliged, Your Honor.
Council seeks permission to move the rebuttal.
Council seeks permission to and the thought is cited, it is humbly requested that the Honorable Commercial Court of Mumbai may be pleased to adjudge and declare that dismiss the suit filed by the plaintiff as being devoid of merit, declare that the defendant is not liable to pay any liability penalty for alleged substandard quality of the first consignment, the same having been duly accepted by the plaintiff without objection, hold that the delay in delivery of the second consignment was due to COVID-19 pandemic and government imposed lockdown, constituting a force majeure event under the contract, declare that the termination of the contract made by the plaintiff, loss of business and property in the interest of justice.
At first, they have admitted to that they will be paying damages, and also they will be paying 20% penalty. On the following grounds, Your Honor, damages as per there is no aggregate liability claim. Also not disclaiming liability claim. And also as per they will broke section 74 of Indian Contract Act, which says that stipulated amount to be specific in case of breach. Your Honor, they have done material breach, and therefore they are entitled to pay 20% as a penalty. Further, that they have mentioned that case Energy Watchdog CERC versus CERC. Your Honor, this citation is of 2017, at the time that there was no COVID. Also, I am aware about the facts, but at this time there is no citation of regarding that. But I know this case is not related with COVID-19. In this case, there was a dispute regarding the change in policies of Indonesia regarding such price. Therefore, this case is not related to COVID-19. And also, moving to further, they are saying that termination is arbitrary. No, Your Honor, as per the contract, we have clearly mentioned termination clause if there is a material breach. So the termination is not arbitrary. And also, government, I have mentioned the government guidelines, applicable guidelines, which says that documents deemed can be moved after the third May. And also, they are saying 20% penalty is excessive. Your Honor, they have same agreed in their at page 1 of their advanced arguments written submission. They are saying that 20% penalty is excessive and punitive. They have same agreed when their contract was being Council seeks to move towards the clear. Therefore, in the light of the issues raised, arguments advanced and authorities cited, counsel for the plaintiff to pass the claim of 20% and 10 lakhs for the loss of business, reputation, and action. Counsel restored.
That query is not been answered.
Your Honor.
My friend had put you that query for non-compliance of section 12 of the Commercial Codes Act. Is it commercial dispute?
No, it's
not a commercial dispute.
Yes, Your Honor, that is a commercial dispute as per section 12 of Commercial Codes Act 2015. But in our case, we have invoked the jurisdiction under section 9 and section 20 CPC, and also we have directly emerged because of the claims. Yes, the main thing as the commercial contracts includes mediation. We are bypassing that procedure.
Section 9 and 20 are perfectly fine. Invoke the jurisdiction of the civil code, that's covered in section 9. Next is section 20, because the defendants are residing in jurisdiction.
Yes,
the cause of action, that is perfectly fine.
Yes.
So let's just conclude your matter. What do you want to say?
We are including that 16 lakhs for 20% penalty, 25 lakhs for non-delivery, and 10 lakhs for the loss of damages, businesses, and hardship. Counsel restored.
The council seeks permission to respond to the plaintiff's submission. Much obliged, Your Honor. The issues raised by the plaintiff are poor quality. Your Honor, it was not as the DEF, that is, the plaintiff accepted the goods, paid full amount, and further no inspection report, no expert evidences, and no laboratory analysis were proved, and no complaint at the delivery. Hence, social media posts cannot amount to the legal evidence. The plaintiff's unverified public accusations amount to defamatory conduct and further demonstrate the absence of bona fide evidence against the defendant. The plaintiff raised the issue about the 20% penalty is unfair. Your Honor, the penalty does not amount to automatic payment. Loss must be shown. DE financial loss. Hence, the penalty is not justified. The penalty raised the issue about the COVID-19 is force majeure and the pandemic is not mentioned. Your Honor, lockdown was imposed by the government and the labor shortage and import ban was a result of it, and the event was beyond the control of the party. Hence, the defendant informed plaintiff and asked for the time. Hence, COVID qualifies as a force majeure. The plaintiff raised that the termination was wrong or invalid. Your Honor, the DEF never replied to the extension request. It suddenly cancelled the contract and this shows bad faith. Hence, the termination was illegal. The plaintiff raised the issue about the no actual loss suffered or the loss of business. Your Honor, market prices fell due to the COVID-19 and DEF could buy towels cheaper and no actual towel loss proved. Hence, damages are speculative. Therefore, there was no quality defect, delay was due to force majeure, termination was unjust and damages are not proved. The suit must be dismissed.
So what you want to say is that since now they could buy cheaper towels, so your non-supply of 20% of the goods justifies the same. That is the third part of your argument. That since the prices of towels or the consumption is increasing. What do you want to say about that? Is the consumption has come down? The consumption of towels has come down, so they have not suffered any penalties on account of that?
It was mentioned in the contract.
That's what I'm asking. What was that part of the contract? Can you please read it out? The third defense, what do you have? People were using the towels, less than people were going to hotels. So the consumption of towels was less. So that is what you want to see, that they did not suffer any penalties.
Sorry, sir, can you repeat?
What was आपको 3 points बताइए जो आपके 3 points हैं defensive and that we are not bound to pay the penalty. Delay was on account of COVID-19 in the third part.
Government price of cotton towels has fallen by at least 20% due to severe economic impact of COVID-19 pandemic, and hence DEF has not suffered any loss due to its inability to deliver the second consignment.
So, what do you want to justify with this argument? Procurement price of
That the damages are speculative.
how in case the price has come down, how does that affect the purchaser? That would affect you.
It has not suffered any loss due to inability of deliver second
They were
consignment.
not purchase cotton. You were the ones who were to purchase cotton or whatever. So how are they affected by this? In case the prices will come down. That is my point. You were to purchase raw material from the market. Like towels and then send it to them. So in case the prices will come down, how would that affect the supplier? It would affect you.
Sir,
It would
the second
rather
consignment was
you
not
were
delivered.
not-
We failed to deliver the consignment.
Exactly, obviously failed to deliver. So if you
That
want
is our
to
loss.
you failed to deliver. My query is different. My query is you want to purchase cotton from outside manufactured towels and then supply. Now you want to argue is that since the price has come down, so who would that affect? You or the supplier? Kindly close your arguments. Let's see.
Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, it is humbly requested that the Honorable Commercial Court of Mumbai may be placed to adjudge and declare that the dismiss the suit filed by the plaintiff as being devoid of merit, declare that the defendant is not liable to to pay any penalty for alleged substandard quality of the first consignment, the same having been duly accepted by the plaintiff without objection, declared the termination of the contract by plaintiff was arbitrary, unlawful and unjustified, and award cost of the present suit in favour of the defendant, and pass any such order, judgment or direction that the Honourable Court deems fit and proper in the interest of justice. For this act of kindness, the counsel for defendant, as is duty bound, shall forever pay. Much obliged.
Council want to counter it by just where ABC said that the intentions of the DEF, but DEF acted to protect the brand, to harass the ABC, as he also timely paid for the first lot of the goods, that is 80 lakhs. So its actions were in good faith and in bona fide exercise of the contractual rights, and the second lot which was not delivered on the time under section 55 times the essence is a big claim. So, Your Honor.
Both plaintiffs are very
एक स्टॉप करते हैं स्टोरी बनानी सी कदों क्या फड़का च कैमरा बनानी थले जी इतने रहते हैं चल सिग्नल देखने आते
arguments and smart legal thinking. The second moot court competition has the true spirit of law, where knowledge meets argument and theory meets practice. This competition was not merely a one-day event, but a journey shaped by a week of planning, preparation, and perfection. From framing the moot court proposition to organizing the rounds, from mentoring participants to ensuring smooth conduct of competition, every stage reflected dedication and teamwork of our organizers. So before we begin with the facilitation ceremony, it is my privilege to introduce our chief guest, Dr. Dhyal Pratap Singh Randhawa, whose presence has added great value to this prestigious event. Dr. Randhawa and dedication to the profession. He served as the president of the Punjab and Haryana High Court Bar Association, a position that reflects the trust legal community. His journey began with the active involvement in student leadership, serving as president of Punjab University Student Council during his law studies, where he demonstrated early commitment to service and leadership. Today, he continues to contribute to both legal practice and academic circles, including representing the registered graduates in Punjab University Senate. Sir, your remarkable journey from student leadership to the forefront of legal fraternity inspires all of us, especially our young lawyers and law students. We would be honored if you could please come forward and address the audience. Please, sir.
I am honored to be here at GS Foundation College of Law. My special thanks to my dear friend, who was my hostel mate. We were together in the department, and I have experienced this after a long time. And Mr. Prashant, both advocates in Punjab and Haryana High Court, our young lawyer, Mr. Mataru, also practicing in the Haryana and High Court. And students. It's a great privilege to be and the kind of perception we have made in minds, the kind of being delivered by seeing this kind of student activism in my past days and being in academics nowadays, who said it in our university, the kind of the youth is very important, especially in case of professional education. It becomes more important and responsibility because the kind of education is to be given to the law student. And the kind of environment and infrastructure and the students representing their roots in the moot court, their views. It's really remarkable. They were well prepared, and like me to decide so which side, like on the top, they prepared very well. The facts of the case, the citations, and other important aspects in the representation of cases on the legal matters. They have presented so very well. Excellent performance to all of you. And that credit goes to your hard work, your parents, those who have given you this environment, your teachers, and the management and staff of this institution. So this is how your performance, your hard work, and the attention paid by the surroundings with you. So that reflection out of you gives this kind of care. You are blessed to have such kind of environment around you to learn and to express. Education is the light in the dark, and the legal education, we have been taught pillars of the society, and nowadays the kind of environment was a typical thing what you provided over at. But it was very difficult. Like if someone asked me how to decide which team was on, they were highly competitive with each other. They were so well prepared. So we were just discussing that. And friends, as you know, law is a profession nowadays where it's no more a genre bias. And in fact, I was attending one event in UILS at Punjab University, and we were supposed to honor few judicial officers. That was a batch around like 13, 14 or 14, 15. And out of 29 judicial officers were we lost to sessions of the 2014-15 and 13-14. Out of 29, there were 23 girls who had joined the judiciary of the states of Punjab and Haryana. So this is a very important aspect. So nowadays, like I'm also contesting one election, which I used to roam in all my election campaign in different parts of Punjab and Haryana. And we find the female, they are numbering ahead. And even in this room, we have much more numbers of female as the students and the staff than the male. So it's a remarkable thing. It's good. And secondly, the profession of law. This is such a thing. You can run as fast as you can. This is the profession where you can run as long as you can. And the rises, there is no limit to it. In this profession, the sky is the limit. So I wish all of you all the best for your career, for your profession. And I again say my thanks to my dear friend, Mr. Shravan Sehgal, leading lawyer in Haryana and High Court, giving me this opportunity to be here with you and to attend this moot court. Because the one moot court I attended was my own. That was the first time I did in 1998, and second time this I was attending again. So thank you very much for taking the time to my guys. Thank you.
Thank you, sir, for your time, wisdom and inspiring words. I would like to request Sharvin sir, our officiating principal, Dr. Jitinder, and Ms. Gagan, to please present a token of love to Dr. Randhawa. Please, ma'am. Please put a huge round of applause.
Please come and check.
We are starting with the facilitation ceremony. Now I want to invite our organizers of Ms. Bhumi and Ms. Anshika. For the final round of judges, we have Advocate Ajay Pathak, advocate from Punjab and Haryana High Court. Thank you, sir, for your time. Next we have Ms. Anshika Baba.
Sir, सामने please.
Ma'am, please join us to facilitate our judges. I want to invite Advocate Ajay Pathak, advocate from Punjab and Haryana High Court. Thank you, sir, for your valuable time.
Yes. हाँ जी. Ready? Sir, सामने. Ready?
Next, we proudly facilitate Advocate Sunny Agarwal. civil advocate for his exemplary work.
आप आइए सामने आ जाइए. Okay. Wait.
Advocate legal excellence and dedication to upholding justice.
कर देना वाली.
Next we have Advocate Rohit Thapar, widely regarded as an encyclopedia of CPC. His profound command over judicial commitment to fairness sent a for legal fraternity. Have a huge round of applause for
Sir. हाँ जी wait. Sir please.
एक और कर देना वाली. बस.
now judges for semi-final round. I want to invite Advocate Shruti Sethi.
हो गई. चिट्ठी वाली कर देना.
Please come on.
Next I would Advocate Balraj Kaur.
देना घट ना. आप एक नुक्कर दे देना.
Please come on. Wait.
Thank you for your valuable time. From faculty, we have Dr. Ratinder Kaur, who judged our semi-final round. Have a huge round of applause for ma'am.
Okay. Yes, come on. This side.
Next we have Miss Divyam Malhotra. Thank you ma'am for always guiding our students and
This side, please. Okay.
next I want to call upon Miss Rachna.
Camera look, sir. Wait. No, there is
Last but not the least, Miss Renu.
background चलती है यार ये चीज़.
Have a huge round of applause for your teachers.
Yes, camera look, sir.
This event would not be possible without the contribution of our student council. I request all the council members to please line up. I'll take your name and you just come one by one.
Hello.
First we have Praneet Kaur. Make it quick guys, please.
Okay, please camera look, sir. Okay, camera.
Chirag.
Okay. Wait.
Sunil.
छोड़ दिया okay please come aside
Rajveer.
this side करे sir okay wait sir please come on wait okay
Hariyar.
sir please come on wait
Harihar.
okay sir please wait okay sir.
Good Simran. Next we have Kiran. Last is Simon. I would like to call upon Advocate Prashant Vashisht and Advocate Karan Matharu for a floral welcome. Please, sir.
sir
A huge round of applause for them.
okay yes come on sir please come wait okay sir सामने हाँ जी wait
Now it is the time you have been waiting for. So, best researcher goes to Rhythm Pahuja, team code 05. Congratulations, Rhythm.
yes come on wait हाँ जी sir सामने please okay
Best speaker goes to Prayag, team code 04.
okay come on wait
Any guesses for the winner team?
Two.
Guesses from the audience? Team code?
Yes.
Okay, so winner team code is
Both were extremely good. Very good. Very good. Very good.
congratulations, Dhriti and Palak.
okay please come on be ready wait
First runner-up team is team code Dev Vikram and Ishika.
सर्टिफिकेट ले लो, कोई बात नहीं। ओके, यस, कोई बात नहीं। ओके, यस, हाँ जी, रेडी? ओके, यस, कैमरा लो, वेट।
Thank you, sir, for your patience. Thank you, sir, you may take your seats. Before we proceed further, I would like to take a few moments to thank the this event possible. Ma'am, you often say that, but this time hats off to you. It's difficult for us to manage. Student team for managing everything so efficiently. A live streaming possible. This is something we attempted for the first time. Thank you, Kinshuk sir, for your time and dedication. And now, last but certainly not the least, I would like to thank the guiding force of our college, our honorary director, Advocate Shravan Sehgal. Sir, without your support, no event or function would be possible. Thank you for always giving us the space and encouragement to explore and grow. With this, I would like to invite Sir to conclude the event with the valuable words of wisdom. Have a huge round of applause for him.
Started thinking about the college. I started looking for affiliation. The first call I made to Mr. Dino. That was the first call. I called him that I have a plan to make a college, law college. We would be needing affiliation. And he was the first person who came to my mind and who actually had the salon. We had a very good time together in the hostel. He was 1 year senior to me. And he was actually a student leader. His best part is that he did law from 95 to 98. I think in our times, I think from 95 to 2005 or 2007, anybody who was connected with the Punjab University was known to it. He is known as DP. And I must tell you that you must have heard the name of SOPU, Student Organization of Punjab University. He was the founder. He was the one who was the first president of SOPU. And at that time we were in the hostel. Earlier the politics was student politics was between PUSU and SOPU. PUSU was stationed at hostel number 1 and he was at hostel number 4. We were our rooms were very together. He was at 340, I was at 356. So, and he has kept the bond alive with everybody from that day. ਤੁਸੀਂ ਅੱਜ ਵੀ ਪੁੱਛ ਲਓ ਮੇਰੇ ਸਾਥੀਆਂ ਨੂੰ ਜਿਨ੍ਹਾਂ ਨੇ ਮੇਰਾ ਲਾਅ ਕੀਤੀ ਹੈ, everybody he still maintains relations with everybody. This is not a small thing. He has been our president of Punjab and High Court Bar Association. And a very honest to the court, very friendly, and he stands with everybody, not even for his voters. This is his quality. And see his grace. From his side. Favor him in the coming elections. Thank you so much for coming. Thank you.
मामले की थोड़ा चल कितों करनी है